Welcome back to another episode of the Counterlawfare Report with Brian Vukadinovich. Brian, thank you for joining me again. I'm so pleased to have you with me here, and thank you for creating this show with me. This is really a unique show. It's not only one of the most important and unique shows on Crowdsource the Truth, there's nothing else like this that I'm aware of. Brian, you're not a lawyer, and we're certainly not offering legal advice here, but you are a pro se advocate and you have extensive experience in defending yourself and even prosecuting your own civil cases and defending yourself in criminal cases. We're going to talk about a very interesting case today, and you've prepared quite a lot of research and information for us, isn't that right?
Yes, Jason, and let me, if I could say, you're exactly right. I think we have a very unique show here, and what we're going to try to do is we're going to try to educate the public, so to speak. A lot of people don't really understand how the legal system works, whether it be in criminal law or civil law, and there's a lot of things that people, if they're ever going to be involved in a case, whether they're on this, whether they're a plaintiff or a defendant or a criminal defendant or whatever, it would behoove the people to really understand as much as they possibly can how the process works, how the lawyers operate, how the opposition operates, and so forth. So as we're moving along here, and tonight we're going to talk about a person that you've had on the show several times, Michael Barden, and the situation he's in his criminal proceedings in Arizona currently at the moment. And we're going to talk about some of the ins and outs and what's going on there and some things that Michael should be looking at and looking into. And then hopefully that the general public out there will be able to get an idea on exactly how things actually operate behind the scenes.
Yeah, and this is a case really that you, Brian, I think are uniquely suited to give insights on. Again, we're not compelling Michael to do anything. We're not instructing Michael. We're not providing him with legal advice. But you yourself were targeted by the local police there in Valparaiso, Indiana, after a mistaken identity charge had them arrest you in the parking lot of a bank. And when the cops were dressed down by the judge in your case for being totally incompetent and arresting the wrong guy, they basically went on a personal vendetta against you to try to ruin your life. Michael's appeared on many, many episodes where he's spoken to us about the targeting that he suffers daily. We recently did an episode of the intelligence assessment with Kevin Shipp, which is one of the shows in our Only on Patreon series here on Crowdsource the Truth, and people can check that out. But of course, Michael has been going through, as you said, a very challenging legal case where he has been accused of, what is it exactly? It was assault with a firearm, aggravated assault, I believe, with a firearm, but he never brandished a firearm. It was his assailant who had the gun. Isn't that correct? Yes,
and what's happening in his case is the charge against him is, as you said, brandishing a firearm, which Michael vehemently denies, and there appears to be evidence to back his defense up in the case. But unfortunately for Michael, that evidence, the prosecutor, for some reason or another, doesn't want to provide that evidence, as the prosecutor is required to do under Arizona law. And also, unfortunately for Michael, from the information that I have about the case, his own lawyer, a Mark J. Victor out of Chandler, Arizona, he has a duty under the attorney conduct codes, under the American Bar Association codes, to vigorously and zealously represent Michael. And there's some questions certainly that are taking place right now, because Michael has asked his attorney, Mark J. Victor, to obtain the body cam of the officers that were involved in the arrest of Michael. And it's my understanding that there were somewhere between 6 and 8 police officers, and several of them for sure had body cams on that would would be the absolute best evidence that you could have.
Right.
It's an actual video of the arrest. And for some reason, the prosecutor in the case has not brought that information forward, or only is willing to bring parts of the video in and so forth, where Michael should have access to the entire video. So there's a serious question here as to what's taking place there in this prosecution in Arizona. Now, if I could, I would like to read the rules out of the State Bar of Arizona, which are called the Special Responsibilities of a Prosecutor.
Sure.
Excuse me?
Yes, please.
Okay. ER 3.8, Arizona Special Responsibilities of a Prosecutor. D as in dog. Make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate the offense. So under Arizona law, the prosecutor must make this disclosure, and the prosecutor has not done that there in Maricopa County in Arizona. And there's a responsibility to do that. And that Arizona rule is also echoed word for word by the American Bar Association Special Responsibilities of a Prosecutor. Word for word. So the Maricopa prosecutor must timely disclose those body cams under the State Bar Rules of Arizona and under the guidelines by the American Bar Association, and hasn't done so.
Wow.
And Michael's own lawyer, Mark Victor, apparently for some reason doesn't feel the need to get that evidence, and that's a major disservice to Michael. That's actually the smoking gun evidence in the case that could actually potentially get the charges dismissed against Michael. So the question is, why does Mark J. Victor, Michael's attorney, either fail or refuse to request that information? The prosecutor isn't allowed to say, well, I'm going to give you this, but I'm not going to give you that. When prosecutors do that, and there's a rat in the room, the lawyer should go to the judge and file a motion and explain to the judge that the prosecutor is in control of exculpatory evidence that will tend to exonerate the party of the charge. But Attorney Victor has not been doing that. And Michael would like for him to do that. Michael has paid a lot of money to Attorney Victor.
Yeah.
So Attorney Victor should either step up to the plate and do his job that he's required to do under the canons that he's required under Arizona and the American Bar Association guidelines, or he should actually just step away from the case and give Michael his money back, refund his money. It's thousands of dollars.
Yeah.
And he could go get a competent attorney somewhere that'll stand up and defend his rights. It's not happening right now.
Now, Brian, what I'm going to do periodically is sort of interject to make sure that I'm keeping up with what you're saying, and hopefully it'll help the audience keep up, because we get into a lot of terminology and things, and I think a lot of people are interested in understanding how the law works, and if they get involved in a case like this themselves, there's a lot of valuable pieces of information that you're giving out. So some of this may seem very basic, but I found myself even getting confused when you first mentioned it to me, and now I've realized that from hearing you say it again. The prosecutor, of course, is the attorney who represents the state of Arizona, who's bringing these criminal charges against Michael. This is very different than a civil case where it's one party versus another. They're both represented by attorneys, and the stakes are usually some sort of money, financial compensation. Michael, of course, has quite a lot at stake, because should he lose this case, he loses his freedom and he will go to jail potentially. So the prosecutor is representing the state of Arizona, right? Yes.
Representing, it's the Maricopa County prosecutor, which proceeds on behalf of the state of Arizona.
Right, so he's representing the county, and he is duty-bound to present not just evidence that would show Michael to be guilty, but also evidence that they're aware of that would show him to be innocent. So if the prosecutor knows that the police have body camera footage that shows Michael throughout the duration of the incident without a gun, and they're not showing that, they're essentially hiding evidence that would prove that Michael is innocent, and that is basically prosecutorial misconduct, isn't it?
Absolutely. It can essentially be a crime, actually. But if I could add, the American Bar Association rule states standard 3-1.2 E. Okay, right there it is. The primary duty of the prosecutor is to seek justice within the bounds of the law, not merely to convict. That's a very important guideline there. So
right.
A lot of people think that, well, the prosecutors are there just to get convictions at whatever cost. The actual American Bar Association rule is they're there to seek justice. So if there's information exonerating a person, a defendant in a case, that prosecutor is bound to reveal that injustice and to make sure that an injustice doesn't happen, not just to convict. The rule says not merely to convict. The particular prosecutor in the case is Michelle Vaikus, V as in Victor, A-I-T-K-U-S. So Prosecutor Vaikus is obligated to provide the entire body cam from point A to point Z, from complete to end, on all of the body cam, not just some of the body cams, not just part of the tape, all of the body cams, the complete body cams, the entire evidence. And that's something that Attorney Victor should be demanding of the judge. The rules are very straightforward about it, because if he doesn't do that, there's a possibility that Michael could actually end up being on the list of all these people in the United States who have been sent to jail, and then later on, several years later, it's discovered that they were wrongfully imprisoned. That shouldn't happen.
Right. I'm trying to find an image of this prosecutor, and it's proving quite difficult. There's this website here, Justia. I've seen patents on this website before, but I guess this is her, Michelle Vaikus. Is that the right name?
That's the correct name.
Well, it's interesting, Brian, because, you know, it wasn't that long ago that we heard in the mainstream news about prosecutorial misconduct in the case of the Bundys. I don't know if you followed that trial very much, but I'm looking here at an article in The Intercept that says the botched Cliven Bundy case was just the latest example of prosecutorial misconduct in Las Vegas. Now, I forget what the exact quote was, but it was eventually, so Cliven Bundy earlier this year, it was described as outrageous misconduct by Nevada prosecutors. Now, you said earlier in this conversation that prosecutors aren't intended just to seek convictions, according to the American Bar Association, but I think it's possible that some prosecutors may believe otherwise, that they do want conviction. What would motivate a prosecutor to seek a speedy conviction rather than justice?
Well, prosecutors, they like to put those notches on their belt. Just like in the Old West, when the gunslinger would kill somebody and then he would put that notch on his belt, prosecutors like to do that with their convictions. And the more convictions they get, the better they feel that they look. Then later on, they run for some public office and they say, well, I prosecuted 75 cases, and in all 75 cases, I got convictions, and therefore you should put me in as Attorney General or as a judge. So that's their motivation, essentially. In fact, it happened to me in Indiana here with Nancy Vadic. She blatantly lied at a criminal proceeding against me in Indiana here, which I had well documented. and then the charge was ultimately dismissed completely, and then she ended up becoming the chief judge of the Indiana Court of Appeals after, you know, what she had done. This is how it works. This is how it works in the United States, in our country, sadly enough, and this is what people need to understand and realize. It's happening, and it's very alarming.
Yeah, it is, I think, alarming for some people to hear, but what you're saying echoes what I've heard before from Larry Klayman and other people. I can't help but think, Brian, you know, we're talking about Maricopa County. It's not New York City. Is it possible that the legal community over there, does Michelle Vaitkus maybe have a personal relationship with the lawyers who are representing Michael, and they agree to sort of work together to move this case through the system, give Michael a plea deal, let's, you know, you get your money from Michael, I get my conviction on the record, and let's move this thing out of here and move it all along? Is something like that possibly happening?
That's highly, now I can't say that's happening for sure, but it's certainly not uncommon for lawyers to appear in front of the same judges in the same county with the same prosecutor on the other end, and then they establish a relationship with one another where they you scratch my back and I'll scratch yours, you get the defendant to plead guilty here in this case, and then I'll do what I can in the other case that we're involved with. So very definitely that's going on, and it's something that we, the public, really don't know behind the scenes, but it's definitely happening. There is no question about that whatsoever.
Right.
And let me, if I could, let me, when we talked earlier about what would motivate a prosecutor to actually try to put an innocent person in jail, I can tell you this. In Indiana, in one of my 10 cases where I was prosecuted, and the prosecutor in the case in LaPorte County, his name was Robert Shilagi in LaPorte County. He allowed, in a criminal proceeding, the police officer had filed an affidavit. He prepared an affidavit, and I talked about this in our show in the past, so I'm not going to go into details with it, but he allowed the officer to get on the stand and tell the jury that he found beer cans in my car, when in reality he found pop cans in my car, and he withheld the affidavit about, and then testified and lied to the jury, and then there was a conviction. But later on, when I obtained that evidence, the governor of Indiana pardoned the conviction, and then it was I was able to get it expunged from the court record. Now, that prosecutor, Robert Shilagi, right there in the article that we're looking at there, he was a deputy prosecutor at the time, and then he ran for the prosecutor of LaPorte County and bragged, he boasted to the newspapers in LaPorte County that my prosecution was his greatest achievement of all of the prosecutions that he did, that when he prosecuted me and got that bogus conviction against me, that was the highlight. That was his biggest case. And then people were calling me and telling me about that, and then he lied. He made a public lie to the newspapers and told them that he got a conviction against me for resisting arrest, which was a blatant lie. I was never charged with resisting arrest. So when I contacted the newspapers, I told the newspapers they had 48 hours to make a retraction of Shilagi's false statement, and they did. And then it was front page. They put it on both newspapers. And then I contacted Shilagi, and I told him that you are using the tainted conviction against me for political gain. You allowed a police officer to lie and perjure himself on the stand. You allowed that to happen. And it is inappropriate for you to be now using the case, my case, for political gain, so he could win the prosecutor's office. Now, lo and behold, several years later, Shilagi ends up himself falsifying. He forged a person's name on an affidavit, and here he is, the prosecutor, committing forgery, a felony in Indiana.
Wow.
And he got suspended, or something happened. They sanctioned him in some way, but he didn't get prosecuted like regular people would. So to make a long story short, now he's mowing lawns is what he's doing. He's mowing lawns in LaPorte, Indiana, instead of being a prosecutor. That's how bad it is.
That's appropriate, at least. I'm glad to hear that he was removed from this position, but it's an interesting thing, Brian. Perhaps we can explore throughout the course of this show how we get to this level of corruption, because when we look at what's going on in the Department of Justice and in our government overall, and then we talk about someone like the prosecutor in a comparatively small county like LaPorte County, you start to get some insight into, you know, if this is a regular practice that you falsify documents, you lie to get whatever you need done, that just, hey, if it ain't broke, don't fix it. That would just keep going and grow and expand. So let's get back to Michael's case for a moment, because we've spoken to Michael very recently, and he has unfortunately accepted this plea deal that was offered to him. He's pled guilty to a crime that he did not commit. And that's the standard way a plea deal works, right? They say, well, plead guilty to this crime and we'll make all this other stuff go away. So if you're being wrongly accused of something, Michael never brandished the gun, you're being wrongly accused and you agree to accept a guilty plea, well, you've just been sort of dealt a lousy hand. What are Michael's options now?
Well, I can say I went through the same thing. I was offered the plea deal and so forth, and I rejected it. I went to trial, and then I went to a jury trial, and I was acquitted of the false charge. And Michael's options are, now it's my understanding that he has went ahead because of the lack of evidence that they're not willing to provide to him. He feels a lot of pressure right now, unfairly so, and he went ahead and signed a plea deal, my understanding. Yeah. And he has a right under Arizona criminal law to withdraw that plea. So under Arizona law, he can withdraw the plea. Now that some of this information is coming forward, where the prosecutor is unwilling to provide that exculpatory evidence, and hopefully his own lawyer, who he's paid a lot of money to, will see the light and finally do his job and go to the judge in the case and file a motion and make the judge make that determination. The judge should be the one saying that you're entitled to that evidence or not entitled to it. So Michael, I believe, I mean, as you said, neither one of us are lawyers, but I've been through this a lot myself, and I know how it works. I know how corrupt the system is on the inside, how unfair it can be, and how corrupt it is. And I know one thing, if it was me, I would have never signed the plea agreement in the first place, but I understand why he did it. He's under a lot of pressure, so that certainly is understandable. But if it was me, I would be withdrawing that plea, and I would be demanding that this lawyer, Mark Victor, who was paid a lot of money to defend him and is just failing to do so by not getting that evidence, that lawyer should go to court and tell the judge Michael withdraws his plea, and he would like for the judge to have an evidence hearing, an evidentiary hearing, and order the state's attorney in Maricopa County to produce that exculpatory evidence. Once that evidence is produced, then Michael can make a rational decision. Right now, it's not a rational decision because there's evidence out there that could clear him of these false charges that needs to be brought forward.
Right, and that's, of course, the definition of exculpatory evidence, is evidence that would clear Michael of these charges. Now, Brian, there's a rather unique and troubling circumstance that's been introduced into this case with regard to Michael's lawyer, and it's the result of a seemingly disinterested third party interfering with the case. Isn't that right?
Yes, there was a person. His last name is Swigert, I believe. Has written a letter to Michael's attorney and brought Michael's case into the picture, and he's got some litigation going, some civil litigation going against you and so forth, and it's just really would seem that would be an interference of a criminal proceeding to interject oneself for a personal reason of a civil matter, to interject it into a criminal. Now remember, Michael's lawyer is an officer of the court. So when he contacted Michael's lawyer in the criminal case, there just isn't really much of a rational explanation for that. And it's very shaky. And I believe that Michael's lawyer should actually bring that to the attention of the judge in the case as well. That's totally inappropriate in a criminal proceeding.
Yeah. Yeah, I mean, certainly if an outside party was a witness to the incident or had some evidence or some testimony one way or the other to say that Michael did it, Michael didn't do it, perhaps that could explain voluntarily injecting yourself into the case. But it seems quite clear that this activity by Mr. Swigert was purely malicious, intended to befuddle Michael and to complicate the relationship between Michael and his lawyer. Now, Michael had voluntarily expressed to us his dissatisfaction with the attorney, but of course, even with, you know, tens of thousands of viewers, it's not necessarily likely that the lawyer would see that. Now, we made no efforts to hide this information from the lawyer, but we didn't specifically bring it to the lawyer's attention. I know you can't anticipate why Mr. Swigert would do that, but does his action have any bearing on Michael's accepting the plea deal, or how would a judge, how can Michael introduce this?
Well, if Michael, now when Michael's lawyer tells Michael that he's receiving correspondence from other individuals from the East Coast in this case, Michael has to start wondering what's going on behind the scenes here. Are these people that, are they involved with this in any way? Is there something going on in the background to do me in? He doesn't, his mind can't operate rationally, actually, knowing that there's interferences coming in like this. And I'll tell you, one thing that's going to be interesting, I'm curious as to what the federal judge may think in the civil case that Swigert's involved in federal court there in New York. When the federal judge in the case learns that Swigert is going out of his way to contact officers of the court now in Arizona, interfering with proceedings there. So that's going to be a very curious development to see what happens when the federal judge in New York finds out what he did.
For sure. And to be clear, Mr. Swigert, as far as I know, resides in California. His lawsuit against me was relocated to New York after it was kicked out by the federal judge in South Carolina, where he initially brought it. I've got the letter here that Mr. Swigert sent. Should we show this, you think, Brian, so people can see it?
Well, sure. I mean, it's been sent to the lawyer in a criminal proceeding, which is a public case. Yeah. And he clearly is saying to the lawyer that he understands that he's representing Michael Barden as legal counsel, and that that he may be called as a witness in the litigation pending against you.
Right.
So it's totally inappropriate to be using. Michael's lawyer has no involvement in the civil case against you. Right. So it doesn't make any sense to be sending the lawyer to the lawyer who's representing Michael in the criminal case. That makes no sense. And Michael certainly has a reason to be concerned about this development. And again, I'm very curious as to what that federal judge in New York is going to think about this when he finds out that Swigert's sending these letters out like this to officers of the court in another state in something that doesn't involve him.
Right. Now, I've been extensively reviewing Mr. Swigert's civil suit against me, and I find it to be totally frivolous and without merit. But of course, even if Michael were a legitimate witness in that civil action, what does Michael's opinion of his criminal attorney have to do with that? Why? And who's to say that this criminal attorney, you know, he doesn't represent, Michael's not named in the civil suit against me. This attorney has nothing to do with Michael being called or not being called as a witness in a civil suit against me, right?
Yes, absolutely. Well, as you can see,
purely malicious.
Absolutely. As you can see here in the letter, as you are well aware, Mr. Goodman has earnestly advised your client not to accept the plea bargain offered by the state of Arizona in Mr. Barden's criminal case. See attached. Further, Mr. Barden has told this worldwide audience that he does not trust you as an attorney. Well, now what is Michael supposed to think when he sees something like that coming in into his criminal case when he's explicitly discussing his plea bargain? It's just blatant interference in the criminal proceeding. And again, the judge in New York, I do not believe is going to take very well to this when this was brought to his attention. And I would think that Michael Barden's attorney, Mr. Victor, would be bringing this to the attention of the judge in the criminal case there in Arizona. This is totally inappropriate. Actually, he could have cause to summon the Swigert individual into the criminal proceeding there and put him on the stand for ruling to show cause, to explain in the criminal proceeding why he's doing this, why he's contacting his criminal defense attorney in the criminal case.
Now, there's another interesting thing about this, Brian. You notice that it's not signed by David Swigert. It's signed by the evidence collection team. Mr. Swigert has a regular practice of sending out threatening and intimidating emails from the evidence collection team. He uses an email address that is spoliation-notice at mailbox.org. Now, mailbox.org is some kind of, kind of anonymous email service that comes out of Geneva or something like that. You can get your email address from mailbox.org, but of course, no attorney would send out an anonymous communication, would they? I mean, what are the guidelines in that regard?
Well, I can tell you this, in any court proceeding, whether it's criminal or civil, all documents must be signed. They have to be signed or they're inadmissible. So the fact that somebody is sending an unsigned document in, right there alone is a cause for alarm. That's a red flag that they're hiding something. They're trying to hide themselves, actually. And I mean, when people start doing that, there's a reason that they're doing that. And that should be dealt with, actually. To come into a criminal proceeding with an unsigned letter under the guise of evidence collection team, this is a criminal proceeding. What evidence could you possibly want to collect in an ongoing criminal proceeding that in any way would be appropriate? There's no rational. It's probably against the law.
I'm curious to know that, if it is. I presume that he would be collecting evidence for the civil case, but even in a civil matter, I mean, I've spoken about this on air before. I've been divorced. I've been involved in many different companies. I've had clients. I've had interactions with business associates. There have been legal proceedings that I've dealt with infrequently in my life, but you know, you receive summonses from a process server, and you get documentation from a lawyer that puts his name on it with his address and his phone number and his email address and his fax number. There's no anonymous letters coming around, and it's quite bizarre.
The proper way to do it, whether it's a civil case or a criminal case, you have to make a proper request for discovery. There's a certain process for it where you make, in a civil case, it's called request for production of documents. And in a criminal case, you file a motion to produce evidence. That's how you do it. You don't send an anonymous letter with some kind of a fictitious name of something to the evidence collection team, which is outrageous to do, and certainly the court in Arizona and the federal court in New York ought to get to the bottom of it. And Michael's attorney should insist that the criminal court judge in his case hold a hearing on it. The federal judge in New York in the civil case should hold a hearing for a ruling to show cause to get to the bottom of it, because we can't have that kind of thing going on. It's just totally 100% inappropriate And the state judge in Arizona and the federal judge in New York should both get to the bottom of it and impose the appropriate discipline, whether it be criminal, civil, either way, but something needs to be done. This has to stop.
Something seems to be happening to your microphone there, Brian. Is everything all right with it?
Yeah.
Oh, okay.
It seems okay.
Okay.
Can you hear me?
Yes. So Swigert really seems to be introducing problems for Michael there. Now, of course, what's happened is this is not a document that's been filed with the court, so it's not in PACER. It hasn't been brought to the attention of either the Arizona court or the New York federal court. That presents a bit of a problem for Michael because the intention of this letter is to create a rift between Michael and his lawyer. And Michael's lawyer, from conversations I've had with Michael, sort of feels like this is over. Michael signed the plea arrangement. Michael's paid tens of thousands of dollars. All the money that he had, Michael has paid to this lawyer. So it might be quite difficult for Michael to motivate this lawyer to do anything additional with the court. And I think Mr. Swigert may have anticipated that from watching the videos. I mean, this is a very predatory move that he's done in terms of lawfare. He really is, if we were to make a counter-lawfare top 10, you know, people who are utilizing lawfare maliciously, right now Mr. Swigert might be at the top of it.
Well, I looked at the civil case there in New York. I looked at the record of proceedings there, and for one thing, he filed a complaint, a 68-page complaint, which is almost unheard of. When you file court complaints, generally, they could be anywhere from 2 or 3 pages to maybe, I mean, a 15-page complaint would be a very extensive complaint. But to have a 68-page complaint, I don't think the judge there, the federal judge in New York, is going to take very well to that. And then I saw numerous other filings, one after another, and I think before it's all said and done, that when you start messing with a federal judge, who's been on the bench for a long time, who has integrity, when you start doing these things to a federal judge like that, it's not going to turn out very well for you. So it's going to be really curious to see what develops with it. But I have a feeling, before it's all said and done in the civil case there, from what I saw in the record of proceedings, that that judge is not going to take very well to what's happening with all of Mr. Swigert's filings, and in the manner that he's filing them. It's just unfortunate that it's happening, and I think the judge there, the federal judge in New York, is gonna, in the end, is going to take care of the situation and effect some justice on this thing before it's all over. That's from looking at the record of proceedings.
I certainly hope that's correct. Now, so what sort of time frame is Michael looking at? He's signed the plea agreement, and what is expected to happen next? The judge will, I mean, if it's signed, he's accepted it, right? What's the next step for Michael?
Well, normally, after a plea deal has been signed, the court will order the defendant to come in, and he'll ask him some questions. He'll ask him, have you agreed to this? And the defendant will say yes, and then he'll ask him a series of questions. If he was under any pressure, under any duress at the time that he signed it.
He was.
Well, absolutely. Michael has every reason to go in and explain to the judge that he signed it because he was very confused about what was going on, and then this letter came in, and it just made him think that, you know, what's going on behind the scenes with people coming in, contacting my criminal defense lawyer, talking about my plea deal and so forth, and my criminal case. So he was absolutely under a lot of duress. I mean, any rational person would understand that. So Michael has every basis under Arizona law to withdraw that plea, and that'll be his decision. And in the interest of justice, I would hope that he would do so. And then in the interest of justice, I would hope that the state court judge in Arizona there orders the prosecutor to produce that exculpatory evidence, and if that prosecutor fails to do so for whatever reason, the judge will very well may just end up throwing the case out of court and may never even see a trial. So that's where these kinds of interferences will come into play, and then we end up with innocent people going in jail off of all this nonsense. How much more money does he have to spend? I mean, most of us don't. We're not rich. Most of the people in our country aren't rich and can't afford this. He's already spent probably all of his lifetime earnings and savings. And he can't afford now, and his lawyer knows that. See, that's what happens with these lawyers. They get your money, and then you're in a bind. Then it's like, well, what do I do now? I have to do what it says, and there's a whole lot of pressure there going on. So, I'm very, I've seen this. I know what's going on. I've been through all of this stuff, and I know how lawyers operate. And they get your money, they fleece you, they get your money, and then you're helpless, basically, and then you'll pretty much do whatever they want you to do, and they've got your money, and they move on to the next person and do the same thing, and then you might be in jail.
Yeah, exactly.
Or something that the nonsense that they had in there about the plea deal, he has to take some kind of a
psychological evaluation
and so forth.
Yeah.
It's ridiculous.
Well, not to condemn all lawyers, but this is the nature of the process, and what you're describing is lawfare. And so whether it's the lawyers doing it or, in this case, an outside third party coming in, knowing that Michael is distressed, people have seen it. He's been on his own YouTube channel. He's been on Crowdsource the Truth. And, I mean, frankly, you don't even need to see the firsthand reaction to realize that, when you're up against a criminal charge, you've spent all your money with a lawyer, you're facing possible jail time, you've got kids, you've got a family, you've got your work that you've got to take care of. There's a lot of pressure for anybody to deal with, and being out of money and feeling like you have no other options. This is what they're trying to do, trying to break the individual down, put them in a state of desperation where they can now be more easily manipulated. Someone who is financially strong, or their constitution is strong, they're mentally strong, can defend themselves. But someone who is broken down and feeling tremendously weakened is the type of person that can be manipulated and taken advantage of. So this is the type of thing we're going to be looking into on this program, to point out these uses of lawfare. Now, Mr. Swigert is conceivably inserting himself as a concerned citizen, but that excuse doesn't necessarily hold water. In a more legitimate situation, where now you and I have pointed out what may in fact be prosecutorial misconduct, could a concerned citizen who is aware of prosecutorial misconduct in a particular criminal case send a notice to the court and say, hey, wait a minute, this lawyer didn't ask for exculpatory evidence, or is that interference as well?
That would absolutely be interference, because that would actually be practicing law without a license. I mean, you can't, as a concerned citizen, you can have concerns, but you have to address those concerns in front of the appropriate body. Now, if he actually is concerned about what's going on, he should contact the Bar Association in Arizona and raise the concern there for disciplinary actions. But you have no citizen has any right to directly interfere with a criminal proceeding by contacting an officer of the court, and then consequently the defendant in the case ends up suffering to the point where he doesn't know what's going on, and then he starts making irrational decisions that have to be rational, because you can't think clearly when this. If somebody's sending letters in with bogus titles on them, with no name to them, and then you're under the gun for looking at a trial, looking at a plea deal, and then things start coming in with bogus titles on them, unsigned, to your own lawyer who is supposed to be defending you, that's going to mess with your mind. Yeah. And it's messed with Michael's mind.
Yep, it has. He described to us that he had a very uncomfortable exchange with his lawyers the day before he was to appear in court and make his decision about this plea arrangement. So rather than talking about strategy or what he may do, he was preoccupied with talking about this outside interference, and the lawyers were upset.
Yes, the bottom line here is Michael's lawyer should be doing two things. First and foremost, he should exercise the rights that Michael has under Arizona criminal law and demand that the prosecutor there in Maricopa County produce the body cam tapes. That's a must. He must do that. If he's not willing to do that, then he should return Michael's money to him so Michael can hire a lawyer who would be willing to do that. And secondly, he should be going to court in front of that criminal court judge there in Arizona and bring this letter to that judge and show that judge what's happening on the outside with the interference and ask the judge to conduct a hearing on that so that Michael can get to the bottom of it and then exert some type of penalty there. That very well could be a criminal activity there that needs to be investigated.
The interference.
Absolutely.
Interesting. Right. Well, Brian, are there any other nuances to Michael's case that you wanted to go over? This is kind of interesting to have these case studies, maybe per show. If we could do that, that might be a good way for us to proceed and actually analyze cases that are, because Michael contends that he didn't do this, that this criminal charge is part of an ongoing harassment campaign. The shows that I've done with Michael under the title Michael Barden, Targeted Individual, have focused on the activities that he has observed and activities that he has documented on his YouTube channel. And he would say that this lawsuit is, in fact, part of that harassment. So, I don't know. I mean, does he have any recourse there?
Well, there's one more thing that I think the audience should hear, because and I get a lot of calls from people with their cases, and almost every call that I get, they're just not happy with the lawyers that they have paid money to and so forth. Under Arizona rules, it explicitly states that the lawyer that represents a person in Arizona, and I'm sure this is going to be the same in most cases in the country, the lawyer is obligated to do what the client asks the lawyer to do, as long as it's not something that's illegal or unlawful. The lawyer must, if Michael says, I reject the plea deal, then the lawyer should accept that. If Michael tells the lawyer, which he has done, that he wants that evidence under the Arizona rules of attorney conduct, his lawyer, Victor, must make an attempt to get those body cam tapes. That's what the rules in Arizona require Michael's lawyer to do. So people out there should understand that when you hire a lawyer, and a lot of people don't understand this, I don't think, the lawyer works for you. You don't work for the lawyer. When you pay the lawyer, he's your employee. But these lawyers want to intimidate people to the point where they want to act as though they're actually the boss,
right?
And not. So people need to understand that. Now, Michael's case, just ask yourself one question: why won't the Maricopa prosecutor's office produce those tapes to him? Just ask yourself that question. Why do you think that is? The answer is very obvious. There's something on those tapes that clears Michael of the charge they have filed against him. That's why it's inappropriate for the prosecutor to be trying to shove a plea bargain down Michael's throat, while at the same time withholding that potential exculpatory evidence. So if anybody watching this show tonight takes away anything at all, and I said there's one statement I made in my book: keep an eye on your lawyer and don't blink.
Interesting. Why would the judge, Brian, not say, hey, where's this exculpatory evidence? It's just not the judge's job?
That's not his job. That judge can't, I mean, there's a lot of things the judge could say, why aren't you you could be in a trial, and then the judge could say, well, why aren't you asking this question, or why aren't you asking for this information? That's not what the judge. That's up to the lawyers to ask. The judges don't have really the authority to do that. Now, if it's a bench trial, they have some latitude to ask some questions, but normally in a jury trial, they don't. It's not for the judge. The judge doesn't represent you. The judge is in the middle. He's the arbiter in the middle. He's got to make sure that both sides are being treated fairly. When you hire a lawyer, it's your lawyer's job to do that. The judge doesn't. That's not going to be a concern of the judge. The only time that's going to be a concern of the judge is when it becomes an issue before him. Okay. If he's brought a motion by Michael's lawyer, Victor, and that motion says motion to compel the body cam tapes in this case, and here's why. That judge is going to have to make a ruling then. He must make a ruling. The judge is either going to say, you must produce those tapes, or you don't have to. I can't imagine the judge in the case saying that they don't have to produce the tapes. That's not going to happen. That's where Michael's lawyer is failing him. It's my understanding that Michael's lawyer told him that, well, what good would the tapes do anyway? What would they do anyway? Well, that seems to be a very ignorant statement, actually. What do you mean, what good would they do? Why do you think they don't want to produce the tapes?
Right.
Just ridiculous. And if I paid a lawyer thousands of dollars and he said that to me, he would be done right there, right on the spot at that moment.
Yeah, I mean, again, you're armed with knowledge that Michael didn't have, and he lacks confidence as a result of lacking that knowledge. It's a good opportunity for me to remind people that Brian has written a book about all of his experiences. The book is called Motion for Justice, I Rest My Case, and you can purchase that book from Amazon.com, even if you aren't planning to be your own lawyer and represent yourself pro se. This is a fantastic book for anyone who's involved in any kind of civil or criminal proceedings to read. It's going to give you a ton of information about how the legal system works, some of the experiences that Brian had getting kind of put through the ringer in that course of his multiple legal cases that he's been involved in. Brian is also part of a grassroots movement, not just here on Crowdsource the Truth with the Counterlawfare report, but he also is very active with the Posner Center of Justice for Pro Ses, and he's helping pro se litigants to obtain justice throughout the country. The Posner Center is located in Chicago, and of course, people can see the interview that Jared and Elizabeth Beck were kind enough to invite me to join them on when we spoke with Judge Posner, and he is a very experienced judge, incredibly kind man. That's a valuable resource, that Posner Center of Justice for Pro Ses. And you know, this exculpatory camera evidence, Brian, it seems like we hear so much about body cams, and it brings me back to the Bundy trial. That was really one of the first trials, criminal trials for sure, that I actually personally went to. And it was extremely interesting because I was only there for a couple of days, but there was testimony from a witness about a football-shaped camera. And more than one witness spoke about this football-shaped camera. I want to see if I can locate it here, because as a camera user and a cinematographer and a digital video professional, I'm pretty familiar with cameras, and I found it extremely strange that a camera would be described as being the size of a football, particularly in 2014. Most cameras are very small. Let me see if I can find this thing. But what happened as a result of Crowdsource the Truth covering that trial is that someone in the audience found this, I believe it was Height Vision or something like that. They found a camera that looked like a football, and I'm not finding it easily right now, but what we were able to determine from that description was some of the technical capabilities of this camera, and I actually emailed the defense attorney and told them, hey, you know, here's this football-shaped camera. Ryan Bundy also described it as having a laser on it. Here it is. I found it. Based on the description from the witnesses and from input from the crowdsourced community, we were able to locate this camera, which does in fact looked kind of like a football. And we were able to determine that this thing had internal memory, because the actual statement made by the prosecutors was that even though these cameras are being utilized on the Bundy Ranch and streaming to 3 different FBI or Bureau of Land Management locations, they made a very specific statement that the streamed output of the cameras was not recorded at those locations. And I think that lawyers are very prone to speak in extremely specific language because they don't want to be called out for lying. What they left out was, it's possible that the footage was recorded in the camera itself. So when I presented these capabilities to the defense attorney, they went back and demanded to see this evidence, and ultimately this evidence was produced. The prosecutors were withholding the evidence because it did in fact support the innocence of the defendants. And shortly after that, I'm not saying that this was my doing, but people have suggested that the efforts of the crowdsourced community contributed, at least in part, and that evidence was produced, and of course the Bundys are out of jail now. So what we're doing is very important.
That's absolutely fantastic that you pointed that out. I mean, there's so many things out there that many of us still don't know in terms of gathering evidence and so forth, especially with technology the way it is these days. So what you pointed out there was very helpful to them.
Yeah.
And let me also add here, in Michael's case, there was one of the documents, the reports in this case, when they were interrogating him, they and Michael was under duress and so forth, and they were trying to force answers out of him. And then, lo and behold, according to one of the police reports in the case, the body cam quit working. They put it right in the report. Now, anybody with any common sense would have to say to themselves, why is that in the report here? Pretty obvious. Probably, in all likelihood, they turned the body cam off because they were actually abusing him, misusing the interrogation process, didn't want to have that on the body cam as evidence. So then they covered themselves by putting in the report, because they knew that the defendant is in all likelihood going to ask for that body cam evidence.
Right.
They can say, oh, well, it wasn't working at the time. So they actually put it in the report. So there's a lot of shaky things going on there in Michael's case that I think a good criminal defense lawyer would be tearing that thing apart at this point. That case should be dismissed.
Absolutely.
The Maricopa County Prosecutor's Office should be dismissing that, either producing that evidence or doing what the rules in Arizona say. Dismiss the case and let justice take its place. That's what should be happening there in Maricopa County with Michael's case.
Absolutely. I'll tell you what, Brian, it certainly seems like police body cams are the least reliable piece of technology I've ever heard of. They always seem to be failing and not recording and not turning on and getting erased and all that stuff. So it's very interesting.
Even worse, they don't. Sometimes I've seen things on the news where when they're taken to task, they just turn them off on their own. I just can't imagine that a police officer not be fired for that.
Yeah.
I mean, it's just ridiculous. I've seen that on news reports where things will happen and allegations are made, and then the police will say, well, I didn't have it on. You know, well, then they should be fired.
Yeah.
That's the reason they have those cameras. That's why there's a lot of people in jail these days. I just today saw an article in an Indiana newspaper here. They had a seminar of some kind at Indiana University Northwest. They had several people there that were wrongfully imprisoned, and then they finally got out with the technology these days and so forth. So there was an article that I read about that just today, as a matter of fact, and there was some justice groups there speaking to it. But we need to understand as a country here, something's got to happen here. And these people, most of these people that are in jail, the ones that are in there, and I talked about this last time, there should be an eye for an eye law in this country. If these prosecutors and these police officers who are perjuring themselves so they can put innocent people in jail, there's no consequence to them. This is going to continue on. But I guarantee you, if they knew that there was an eye for an eye law, where if they were caught but they're alive later on down the road, and somebody had to spend 23 years in jail, then they would have to spend 23 years in jail when their lie is finally discovered and proven. You wouldn't have so many innocent people in jail like we do today. It's a big problem.
Accountability, right. You know, Brian, I think that you and I can perhaps set some goals for the Counterlawfare report. Perhaps as the show progresses, we could explore certain topics where, for instance, how could we propose to different states a law that would mandate that police body cameras are always on and are recorded in addition to on the police officer's body itself? They should be live streamed to a public server somewhere. The police are supposed to be working for the people, protecting and serving the citizens who pay taxes and pay to have government services like police officers. So them being able to manipulate evidence, even as much as turning it off to choose when they are or are not recording evidence, doesn't seem reasonable to me. I think as long as a police officer is on duty and not using a restroom or something like that, that camera should be on. And I also think we should have cameras inside of court proceedings. I find it very strange that when I go down to the federal court building to file various things with regard to Mr. Swigert, they have signs everywhere. No cell phones are allowed in the building, no cameras allowed to record the proceedings. I would like to see that changed.
Well, I can tell you, I can give you a great example here. In the 7th Circuit Court of Appeals in Chicago, the Federal Court of Appeals, Judge Richard Posner, he proposed to the Chief Judge of the 7th Circuit, Diane Wood, that the courtroom be open to the public with recordings, that there be a video recording of all of the arguments and proceedings in court. Chief Judge Wood told Judge Posner that they couldn't afford that.
Come on.
Guess what? Judge Posner told Chief Judge Wood that he would pay for it out of his own money.
Wow.
He would pay for it personally. So it wasn't going to cost any money to the government at all. Judge Posner, and guess what? What do you think happened? After Chief Judge Wood said, we can't do that because we can't afford it, and Judge Posner said, well, that's no problem because I'll pay for it out of my own funds. What do you think she did?
I don't know.
She said no. So, in effect, her first reason wasn't true, because after she was given the option that Judge Posner would pay for it, she still said no. Now, why wouldn't Chief Judge Wood want cameras in the courtroom? Well, I can tell you why. Because there's a lot of things that are taking place in that particular court, in the 7th Circuit in Chicago, that Chief Judge Wood doesn't want the public to see. Exactly. And I can tell you, I'll give you a good example. I was there for a case, and one of the judges there, Michael Caney, went on a verbal tirade against me because I had the audacity to stand up for my rights. This was done in a courtroom where if there would have been cameras on there, everybody could have seen how inappropriate and ridiculous this judge, Michael Caney, was. And then when I found out later that there was some shenanigans that he was participating in the case against me, and I filed the papers with the 7th Circuit, and then he recused himself afterwards. He had a duty to recuse himself beforehand, but he didn't do it. He waited until I filed papers when I found out what he was doing, and this is why Chief Judge Wood doesn't want cameras in the courtroom there in the 7th Circuit, because she does not want the public to see what's taking place there. So that's right there. I experienced it firsthand. There's a lot of things going on in the courtroom that the judges don't want to touch. Now remember, judges, these are public employees. They're being paid by the taxpayers. A judge is a public employee, just like the custodian in the courthouse. The only difference between the custodian and the judge in the courthouse, the judge makes more money. They're both paid by the taxpayers. They have different jobs, but they're both public employees. We can see what the custodian is doing when he's cleaning the building. The public can. The public should be able to see what the judges are doing in the courtroom. The fact that the courts don't want the public to see, that's a disgrace. That should change.
Yeah, and that's something we're going to continue to dig into. Hopefully we can affect a change somewhere down the road. The book, once again, is Motion for Justice, I Rest My Case. Brian Vukadinovich is my guest, and the show, of course, is the Counterlawfare Report. Brian, thank you so much for joining me. This has been a very informative episode, and we're going to continue to do this every week. So I look forward to speaking with you next week. I want to thank everyone for watching, and hopefully people will buy the book. Thank you so much, Brian.
Thanks, Jason. It was a pleasure.
Take care.
Thank you.